There are a lot of conversations out there about how to fund your living trust, and most of those conversations tell you the same thing. Get all your assets into the trust so your family avoids probate when you are gone, and that is generally the right advice. But here's the part almost nobody talks about, and it is the part that actually causes the most damage in the real world. There are specific assets, 5 of them, that you absolutely should never put into your living trust. And I do not mean it is slightly inefficient to put them in. I mean, putting them in can trigger immediate tax consequences, create personal liability, invalidate protections those assets currently carry, or expose your entire trust to lawsuits that were never supposed to touch it. Most seniors who have gone through the process of setting up a living trust were never told any of this. Their attorney created the document, told them to fund it, and they went home and started retitling everything in their name, including assets that should have stayed out entirely. Today, I am breaking down all 5, what the consequences are of getting it wrong, and exactly what you should be doing with each of these assets instead. This is not legal advice for your specific situation, and you should always work with a qualified estate planning attorney. But what I am going to give you today is the foundational knowledge you need to walk into that conversation and understand what you are dealing with. So let's get into it. The first asset that should stay outside your living trust is something most people never even think to question. It is clears throat your vehicles, and I am talking about everything in that category. Your car, your truck, your boat, your RV, your motorcycle, any titled vehicle of any kind. A lot of people hear the advice to fund the trust and assume that means everything goes in. The car is in your name, so it goes in the trust name. That logic makes sense on the surface, but there are 3 separate reasons why putting vehicles into a living trust creates problems. And every one of those reasons is significant enough on its own to stop you in your tracks. The first reason is that you simply do not need to put vehicles in the trust to keep them out of probate. The whole point of funding a living trust is to avoid the probate process for your assets when you pass away. But vehicles already have a simple established transfer mechanism that bypasses probate entirely. When the person who owned the vehicle passes away, the successor trustee or the intended beneficiary typically only needs a copy of the death certificate to transfer that vehicle to the new owner through the DMV. No probate required, no court involvement. The title transfer is straightforward and handled at the state level. So the entire premise of putting the vehicle in the trust to avoid probate is already achieved without doing so. You can simply note in your trust document or your final instructions who you want to receive the vehicle. Your son gets the truck, your daughter gets the car, whatever the case may be, and your successor trustee handles the transfer when the time comes. You got the probate avoidance result without the complications that come from retitling the vehicle into the trust. The second reason is far more serious, and it involves lawsuits. When you retitle your vehicle into the name of your living trust, you are advertising the existence of your trust to the world. That matters enormously if you or someone driving your vehicle is ever involved in an accident. Think about what happens when a car accident results in a lawsuit. The plaintiff's attorney does research on the defendant. They run a title search on the vehicle involved in the accident. If that title shows the vehicle is owned by a living trust, every experienced litigator knows what that means. It means there is a trust. And a trust almost certainly has significant assets inside it, assets that are now a target. The attorney will name your trust as a defendant in the lawsuit. Your trust and everything in it becomes part of the litigation. Property, investments, accounts, all of it is now potentially exposed to a judgment arising from a car accident that should have had nothing to do with your broader estate. If you keep the vehicle in your personal name, the lawsuit stays in your personal name. Your trust remains insulated from that exposure. This is a protection that most people give up without ever knowing they had it, simply by retitling the car. The third reason is insurance. When a vehicle is owned by a trust rather than an individual, insurance companies frequently struggle to handle it properly. You will find that some insurers do not want to issue a policy on a vehicle titled in a trust name. Others will issue the policy but require additional documentation, add complications to the claims process, or charge higher premiums to account for what they perceive as an unusual ownership structure. None of this complexity exists if you simply keep the vehicle in your own name. The insurance relationship stays simple. The premiums stay normal, and you avoid a situation where a paperwork issue at the insurance company creates problems at exactly the moment you need the policy to perform. There are limited situations where titling a vehicle in a trust name might make sense. For instance, if someone is prioritizing anonymity for specific personal security reasons and they have worked through the insurance implications in advance. But for the overwhelming majority of people, the right answer is the same. Keep your vehicles in your own name. Note your wishes in your trust document or final instructions, and let the standard death certificate title transfer do what it was designed to do. The second asset that must stay outside your living trust is your retirement accounts. This category includes your IRA, your 401k, your 403b, your 457 plan, your Roth IRA, and your annuities, every single one of them. And I want to spend real time on this one because the consequences of getting it wrong are immediate, severe, and in many cases completely irreversible. Here's the foundational concept you need to understand. IRA and 401ks and annuities are not just accounts. They are trust agreements in themselves governed by the tax code operating under their own special rules that have accumulated decades of legal and regulatory structure. They are tax-advantaged accounts, meaning the government has given you a special benefit. The money inside grows either tax-deferred or tax-free depending on the type of account, and you only pay income tax when distributions come out, typically during retirement when your tax rate may be lower. That tax advantage status is what makes these accounts so powerful as retirement savings vehicles, and that status is tied directly to how the account is structured, who owns it, and how it is titled. Now, here's what happens when someone tries to retitle their IRA or 401k into the name of their living trust. The IRS treats that retitling as a distribution, not a transfer, not a reorganization, a distribution. When you distribute money out of a traditional IRA or a pre-tax 401k, that money becomes taxable income in the year of the distribution. If you have a $400,000 IRA and you retitle it into your trust, you could be looking at $400,000 of taxable income in a single year. At ordinary income tax rates, depending on your other income and your state, that could generate a tax bill of over $100,000 or more immediately. All of the tax-deferred growth that took decades to build would be subject to taxation in one calendar year. Additionally, if you are under the age of 59 and a half when this happens, you would also face a 10% early withdrawal penalty on top of the income tax. The financial damage from this single mistake can be catastrophic and permanent. So, what do you do with these accounts instead? The answer is beneficiary designations. And getting this right is one of the most important estate planning actions you can take. Every IRA, every 401k, every annuity has a beneficiary designation form. That form tells the financial institution who receives the account when you pass away. Assets that pass through a valid beneficiary designation do not go through probate. They transfer directly to the named person. This is how retirement accounts were designed to work. The standard approach for most people is to name your spouse as the primary beneficiary and then designate your living trust as the contingent beneficiary. The contingent beneficiary only receives the assets if the primary beneficiary, your spouse, is no longer living. Naming the trust as contingent beneficiary allows the trust's terms to control how the assets are distributed in that scenario, giving you the protection and control you were trying to achieve without creating a taxable distribution. But there is an important warning here that many estate planning discussions miss entirely, and it relates to a federal law called the Secure Act. Under the Secure Act, when most non-spouse beneficiaries inherit a retirement account, they are required to withdraw the entire balance within 10 years of the original owner's death. This is called the 10-year rule. This change, which went into effect in 2020, significantly impacts how retirement assets flow through estates. If you name your living trust as the contingent beneficiary, and your trust is not specifically drafted with provisions that comply with the requirements for what the IRS calls a see-through trust or a look-through trust, the financial institution's legal and compliance department may not recognize the trust as a valid designated beneficiary at all. That could mean the assets are distributed in a single lump sum and taxed entirely in 1 year, or distributed over a very short window, neither of which was your intention. The practical upshot is this: If you want to name your living trust as the beneficiary of your retirement accounts, you need to work with an estate planning attorney who specifically understands the Post-Secure Act rules and who can draft the trust provisions in a way that satisfies the IRS requirements. This is not a do-it-yourself update to your beneficiary form. It is a specialized planning exercise that requires the trust document itself to be structured correctly. The more common and less complicated approach for many people is to simply name your children or other intended beneficiaries directly on the beneficiary designation form, not the trust, and to make sure you have also named contingent beneficiaries, so there is a clear succession if the primary beneficiary does not survive you. What the beneficiary designation form says controls not your will, not your trust document, the form itself. If your beneficiary designation names an ex-spouse from a prior marriage because you never updated it, that ex-spouse receives the account. The trust document cannot override an outdated beneficiary form. This is why reviewing every single beneficiary designation as part of your estate planning process is not optional. It is one of the most critical actions in your entire plan. There is one additional scenario worth understanding clearly. If your intended beneficiaries are young children, perhaps grandchildren you want to protect, you may actually want the trust to be the beneficiary of certain retirement accounts because a minor child legally cannot manage a large inherited IRA, and the court process required to set up a custodial arrangement for a minor is exactly what you were trying to avoid by having a trust in the first place. In that specific situation, working with an attorney to name the trust as beneficiary with proper see-through trust drafting may make sense. The key is that this decision is made deliberately with full knowledge of the tax implications and with trust language that was specifically drafted to comply with the current rules, not by accident, not by assuming the trust should receive everything, but as a conscious, informed choice made with professional guidance. The third asset to keep out of your living trust is your life insurance policy. And I want to be precise about the language here because this is an area where the specifics matter enormously. I am talking about the policy itself, the document that creates the life insurance contract, not the death benefit. The policy here is the essential principle. Life insurance proceeds, the money paid out when you die, already bypass probate automatically. They go directly to whoever is named as the beneficiary on the policy. That means the core reason for putting an asset into a living trust to avoid probate does not apply to life insurance in the first place. The probate avoidance is already built into how the asset works by design. If you name a specific individual as the beneficiary of your life insurance policy, those proceeds are paid to that person directly and quickly, typically within a few weeks of the claim being filed. No trust required, no probate, no court involvement. When you own a life insurance policy in your own name, as most people do, you have complete control over it during your lifetime. You can change the beneficiary. You can borrow against the cash value if it is a whole or universal life policy. You can adjust the coverage. You can surrender the policy if your circumstances change. All of that flexibility disappears the moment you transfer ownership of the policy to a trust. A revocable living trust retains your control because you are the trustee, and the trust is revocable. But here is the problem. Because you are still treated as the owner of a revocable trust for tax purposes, the life insurance proceeds are still included in your taxable estate if the value of your estate is large enough to be subject to estate taxes. This matters primarily in states with lower estate tax thresholds. In 2026, the federal estate tax exemption stands at $15 million per individual, which means the vast majority of people will never face federal estate tax at all. But certain states have their own estate taxes with much lower thresholds. Massachusetts, for instance, has a state estate tax with an exemption far below the federal number. If you live in a state with its own estate tax and your estate, including life insurance death benefits, approaches or exceeds that threshold, the approach you use for life insurance ownership needs to be part of a broader tax planning conversation. The right way to handle life insurance within your estate plan for most people follows a straightforward structure. Name your spouse as the primary beneficiary on the policy. Name your living trust as the contingent beneficiary. This means if your spouse is alive when you pass, they receive the life insurance proceeds quickly and directly, exactly as intended. If your spouse has predeceased you, the proceeds flow into the trust, where your successor trustee manages and distributes them according to the terms you have already established. The children receive their inheritance under the conditions you set, the ages and circumstances you specified, with the protections you built into the document. This structure gives you the clean, direct payout to a surviving spouse that life insurance is designed to provide, while also giving you a backstop of control and protection through the trust for the scenario where the spouse is no longer there. Now, there is a separate structure that is worth knowing about for people with larger estates or significant life insurance policies, and it is called an irrevocable life insurance trust, commonly abbreviated as an ILIT. An ILIT is a completely different animal from your revocable living trust. It is a separate standalone trust that is specifically designed to own life insurance policies. When the ILIT owns the policy instead of you, the death benefit is paid into the ILIT when you die. And because the ILIT is the owner rather than you personally, those proceeds are generally excluded from your taxable estate for estate tax purposes. If you own a substantial life insurance policy and your combined estate is large enough that estate taxes are a real concern, an ILIT is worth discussing with an estate planning attorney. The trade-off is that an ILIT is irrevocable, meaning once it is established and the policy is transferred in, you give up the ability to change the trust's terms or reclaim the policy. There is also a 3-year rule to be aware of. If you transfer an existing policy into an ILIT and you die within 3 years of that transfer, the estate tax exclusion may not apply, and the proceeds would still be included in your estate. For this reason, the most effective ILIT structure involves the trust purchasing a new policy directly rather than receiving a transferred policy. So, the 3-year clock never starts running. An ILIT is not the right tool for every situation. It is a specialized estate tax planning vehicle, and it comes with administrative requirements and ongoing maintenance that a revocable living trust does not. But if your life insurance death benefit, combined with your other assets, creates a potential estate tax exposure, it is a powerful option worth understanding. The fourth asset to keep outside your living trust involves something that trips up a large number of people, and that relates to a unique concern for business owners, professionals, and anyone involved in activities that carry inherent liability risk. I am talking about your business interests and professional practice assets, with a very specific caveat that applies differently depending on how your business is structured and what kind of liability that business carries. If you own a business, the question of whether to place that business interest in your living trust is one that requires a careful conversation with both your estate planning attorney and your business attorney. And the answer depends heavily on what kind of business entity you have. Here's the core issue. A revocable living trust offers no liability protection. This is one of the most common misconceptions I encounter. People set up a living trust and assume that because their assets are now held in the trust rather than in their personal name, those assets are somehow protected from lawsuits and creditors. That is not how a revocable trust works. Because you remain in control of the trust, because you can revoke it, amend it, and access its assets at any time. The IRS and the courts treat a revocable living trust as an extension of you personally. Your creditors can reach the assets inside your revocable trust just as easily as they can reach assets you hold in your own name directly. Now, for a business that carries significant liability, placing that business interest into a revocable trust can actually create complications that make things worse rather than better. If your business is an LLC or a limited partnership, those structures have their own liability protections built in, specifically the separation between business liabilities and personal assets. When you retitle a business interest into a living trust without the right structure, you can inadvertently pierce the veil of that protection, particularly if the way the retitling interacts with state LLC law was not handled correctly. Additionally, if you are a licensed professional, perhaps a physician, a dentist, an accountant, or an attorney, professional practice law in many states regulates who can own interests in professional practice entities. Transferring a professional corporation or professional LLC interest into a trust without verifying that the trust structure complies with the relevant professional licensing rules can put your license, your practice, and your business entity's legal standing at risk. This is not a hypothetical concern. Estate planning attorneys who work with professionals regularly encounter situations where a well-intentioned trust funding exercise created a professional licensing compliance issue that required significant legal work to unwind. The right approach for most business owners is to work with both an estate planning attorney and a business attorney to determine the correct structure for your specific entity type. For many situations, a pour-over will combined with specific assignment agreements that are separate from the trust document itself is a cleaner mechanism for transferring business interest at death without creating complications during your lifetime. For certain business structures, placing the interest in the trust during your lifetime may actually be appropriate, particularly if the trust document has been reviewed by someone who understands the relevant LLC operating agreement requirements and state law. The point is that this is not a one-size-fits-all answer, and blindly retitling business assets into a trust because you funded everything else that way is exactly the kind of mistake that creates expensive problems. The fifth asset to keep out of your living trust is one that the majority of seniors I speak with have never considered in this context, and it involves your health savings account, your HSA, or a medical savings arrangement of similar structure if you carry one. If you have been using an HSA as part of your healthcare or retirement strategy, understanding what happens to it at death and why a living trust is the wrong structure for it is important. An HSA, a health savings account, is a tax-advantaged account that operates under federal rules very similar in structure to an IRA. Contributions go in pre-tax or tax-deductible. The money grows tax-free. Withdrawals for qualified medical expenses are tax-free. This triple tax advantage makes an HSA one of the most powerful savings vehicles in the tax code, and many financial planners encourage seniors to think of an HSA as a secondary retirement account, because at age 65, withdrawals for any purpose are no longer subject to the 20% penalty that applies to non-medical withdrawals made before that age, though they are taxable as ordinary income, just like a traditional IRA withdrawal. An HSA is tied to a specific individual. It is not a jointly owned account. It is not transferable between spouses in the same way a traditional IRA can be rolled over. If you retitle your HSA into the name of your living trust, the same core problem that applies to IAS applies here. The retitling is treated by the IRS as a distribution. The full value of the account becomes taxable income in the year of the distribution. All of the tax advantages that made the HSA valuable are eliminated in a single filing year. This is a particularly painful mistake for people who have spent years building up a significant HSA balance as part of a deliberate healthcare and retirement funding strategy, only to trigger an immediate large taxable event by retitling it. The correct handling of an HSA within your estate plan is to use the beneficiary designation process just as you do with your IRA and 401k. Name your spouse as the primary beneficiary. A surviving spouse who inherits an HSA can continue treating it as an HSA after your death, maintaining all of the tax advantages. A non-spouse beneficiary who inherits an HSA, on the other hand, faces the full taxable distribution in the year of death, which is a limitation of the law as it currently stands. This is why reviewing the beneficiary designation on your HSA and making sure your spouse is named rather than your estate or an unrelated party is an important planning step. Now let me bring all 5 of these together and give you the clear picture of what to do instead of putting these assets into your trust. Vehicles stay in your personal name. Note your wishes in your trust document or final instructions. The standard death certificate title transfer at the DMV handles the probate avoidance automatically. Your trust stays insulated from vehicle-related liability. Retirement accounts, meaning your IRA, your 401k, your 403b, your 457, your Roth IRA, and your annuities never get retitled into the trust during your lifetime. Retitling triggers a taxable distribution. Instead, use beneficiary designation forms. Name your spouse as primary beneficiary. Name your trust as contingent beneficiary if the trust is drafted with proper see-through trust language for Post-Secure Act compliance, or name your intended beneficiaries directly on the form. Review every beneficiary designation form annually and after every major life event. The form overrides your trust document. It overrides your will. It controls. Life insurance policies stay in your personal name for most people. Name your spouse as primary beneficiary and your trust as contingent beneficiary. For people with large estates and significant life insurance death benefits, explore an irrevocable life insurance trust with an estate planning attorney, keeping in mind that an ILIT is a separate structure from your revocable trust and involves its own set of rules, costs, and irrevocability that must be understood before committing. Business interests require a conversation with both your estate planning attorney and your business attorney before anything is retitled. The right answer depends on your entity type, your state's LLC law, your operating agreement, and whether your business involves professional licensing. Your HSA stays outside the trust. Name your spouse as beneficiary on the HSA designation form and keep it updated. Everything else, your home, your investment accounts, your bank accounts, your real estate holdings, your personal property, the pieces of your estate that do not have their own probate bypass mechanism built in. Those are exactly what your living trust was designed to hold. Get those assets funded into the trust. Make sure the trustee names are correct on deeds and account titles. And make sure your trust document is reviewed regularly by an estate planning attorney to reflect any changes in your family, your assets, or the law. The 5 assets I covered today bypass probate just fine on their own when handled correctly, either through the standard title transfer process for vehicles, through beneficiary designations for retirement accounts, life insurance, and HSAs, or through specific business planning appropriate to your entity structure. What they do not do is benefit from being inside a revocable living trust, and what they actively risk when placed inside one ranges from unnecessary complication to immediate and severe tax consequences to exposure of your entire estate to liability you never intended. Understanding the distinction between what goes in and what stays out is not a minor administrative detail. It is one of the most consequential decisions in how your estate plan actually functions when your family needs it to work. The trust is a powerful tool. Use it for what it does well and leave the assets outside that are better off on their